Good evening, everyone. Shall we begin? My name is Uglješa Grušić. I'm an associate professor here at UCL Laws, and it is my distinct pleasure to welcome Richard Hermer KC from Matrix Chambers, who will be our speaker tonight. Richard is specializing in what is on his website described as public and private law litigation, domestic and international law. I don't think that really explains what Richard actually does. I mean, he's a real rock star in the field. And as many of you know, he is covering in his practice quite a lot of different things, including, I find that personally very interesting, cases against multinational companies and also cases against the state. I will just say a few words about each area of his practice, and then I will let Richard obviously tell us more about tonight's topic. So he has pioneered cases against multinational companies, and many of us will be familiar with cases like Vedanta or Okpabi versus Shell, where the Supreme Court accepted the idea that parent companies owe a duty of care to employees and people living in the vicinity of the operations of their overseas subsidiaries. And they also understand that now they are testing whether this particular idea can apply in the context of supply chains. So there have been some really exciting cases like Begum versus Moran and quite a few others. And they also understand that they're now testing the theory whether unjust enrichment can be used in addition to tort law to remedy human rights abuses. On the other hand, Richard's practice is also focusing on claims against the state, claims against the UK government, and he's argued many different kinds of cases in this field, including cases concerning historical wrongs, so colonial wrongs, cases like Mau Mau concerning the Kenya emergency, but also there's quite a few modern wrongs cases under his belt, including cases concerning things that allegedly went wrong in Iraq and Afghanistan. There are cases where the UK government has been sued for its complicity for assisting the Americans in the war on terror and wrongs that happened in that context, including several cases concerning Guantanamo detainees. And also there are a few cases concerning the provision of defective equipment to British soldiers who then were injured as a result of that on the battlefield. Now, these cases raise really an impressive range of different issues, including the relationship between public international law and domestic law, the extra-territorial application of human rights regime, Crown Act of State, Foreign Act of State, state immunities, and a number of other issues. The list is, I have to say, really, really impressive. On top of that, Richard does a lot of other interesting things. So he has his own podcast, Matrix Chambers Rule of Law Pod. I would advise you to listen to it. It's really very interesting. And for example, he's also a member of the Ukraine Legal Task Force on the accountability for war crimes in Ukraine. Tonight, he will be talking about some of these things. And the title of his talk is Getting the Balance Right, Courts, Armed Conflict, and Human Rights. This is a very important topic and also something which is very, very current, given that Boris Johnson's government introduced the British Bill of Rights bill, which Theresa May's government,
this week,
Liz Truss.
Last week.
Liz Truss, she withdrew it, and then the latest Prime Minister, Rishi Sunak's government, they will probably reintroduce it. And one important clause in that bill says that human rights claims against the army probably will not be allowed, although obviously the clause is subject to interpretation. So Richard, please.
Thanks so much. I'm going to stand up. I'm just used to standing up when I'm talking. There's an occupational thing. So look, thank you so much for the invitation. It was a very easy one to accept. That's partly because there's nothing more than barristers like than talking about their own cases, but it's also because the intersection between armed conflict and accountability in the domestic courts has really proved to be such a kind of fertile and fascinating area over the past decades. And it's produced cases that are not simply interesting for themselves, but really because of, more interestingly to my mind, about what they tell us about how international law develops generally, including the development of remedies for wrongs that a generation ago would have thought to be beyond the reach of domestic redress. And also because I think what they tell us about the kind of constitutional framework, our own constitutional framework, and the role of the courts more generally. So it was a very easy invitation to accept. And I'm going to divide my talk into three parts. So firstly, I'm going to survey some of the cases that our most senior courts have dealt with in the 2 decades following the 9/11 attacks, not least the subsequent, in fact, consequent wars in Afghanistan, Iraq, and what was framed more generally by its sponsors as the war against terror. So I'll look at some of those cases. Secondly, I'm going to offer some thoughts as to what, with the advantage of hindsight, some of the factors were and are that might explain the approach that the courts have adopted. And then thirdly and finally, I'm going to just proffer some thoughts from the legal front line about the extent to which the balance that the courts have made is the right one or not. But I'm going to start with a disclaimer. So unlike many people in this room, I'm not really an international lawyer. I'm a bit of a fraud, if you're going to, for that purpose. I'm better described as a litigator who deploys international law. And that's a distinction that's relevant when I'm standing in this institution, because although I've argued the case, many, not all of the cases we're going to discuss tonight, it's highly likely that there are going to be others here who are going to know far more about them than I do, and will certainly have a far greater recall about their detail, their nuance, and their general significance. And that, to my mind, reflects a rather material difference between the academy and those in practice. And indeed is actually, on a personal level, a source of frustration I've long had. I use international law as a tool to be deployed when necessary and appropriate in human rights litigation. And the reality of a busy practice at the bar is that there's little time for deep contemplation or wide reading around a given subject. Rather, like magpies, we scavenge for the best arguments that are available to help a given client's case. And we don't invite the kind of complexity and nuance that delights the academy. In fact, on more than a few occasions, I've been in teams that have academics, and I just let out kind of a sigh of exasperation when I sort of say, well, what's the answer to that? And they go, well, it's very interesting. I don't want interesting. Oh no, what's the answer, please? And the other reality of practice is that once you finish one case, all the details that have been at the forefront of your mind in an instant vanish. So, I mean, I was rereading today Serdar Mohammed, which is a case I'll return to shortly, and looking at the detail. And there were bits of that I just simply couldn't remember. Whereas there was a stage in which you're arguing it before 9 justices in the Court of Appeal, you're absolutely made sure you know the answer to everything. But it goes. And more than once, on a personal note, I've longed for the opportunity for the clock to stop and to have time to go back in depth to the fascinating issues and think about them in a more profound way. So let me turn to the cases anyway. Over the course of the past 20 years, the courts of England and Wales have considered a range of cases whose volume and subject matter would have seemed unimaginable to previous generations of judges and lawyers. So by way of just the high-level summary, the courts have considered the rights of those detained by UK forces overseas, including the right to review multiple aspects of the legality of detention, including the right of habeas corpus, leading ultimately to the settlement of hundreds of cases brought by civilians in Iraq and Afghanistan. And there have also been scores of cases concerning treatment, or often mistreatment of detainees, including cases about murder and torture, as well as cases that have addressed conditions in detention. And the courts have had to examine not simply the accountability of the United Kingdom for the acts and omissions of its own armed forces and intelligence services, but wider liability for joint operations and complicity in the wrongdoing of others. And these cases have been examined in the context of international armed conflicts and non-international armed conflicts, as well as conflicts outside the scope of IHL in the realm of counter-terrorism. These cases have been litigated through the lens of the Human Rights Act and through private law. From a legal nerd's perspective, what's made these cases so interesting is that it's called for an examination not simply of the different legal frameworks, but working out how they interplay together or how they should interplay together. And our courts have had to grapple with domestic, public and private law in the same case as they've had to work out how it interrelates to regional treaties in the form of the ECHR. They've had to work out the overplay with international humanitarian law in IACS and in NIACS, as well as the interplay of the United Nations Charter. Unprecedented, certainly in English and Welsh legal history. Now, I'm going to just describe a few of the cases. I'm going to be brief because many of them may be known to you, but also because I actually find it more interesting to ask why they were decided that way rather than what they decided. And I'm going to put the cases against the military, both in the IAC and NIAC scenario together, with cases against the security services. Now, of course, those cases raise separate issues, and to some degree, we're on a different legal framework. But there was, to my mind, an important theoretical overlap, which is all about justiciability. When is it appropriate for the courts to engage, and when is it not? And for ease, I'm going to break those down to two types of cases: cases against the military arising out of liability for our own troops or agents, and secondly, in respect of complicity with the alleged mistreatment by third-party states. Now, as to the first category, claims against the UK for its own alleged wrongdoing, my starting point was one of the very first cases emanating from Iraq, which was the case of Skeini, in which, as a very young junior barrister, I was asked to intervene in the Court of Appeal and then the House of Lords, and led by a QC whose career subsequently nosedived, called Keir Starmer. Skeini was a foundational case, not just because it was one of the first in its kind by way of subject matter, but also because it provided the legal platform under which much subsequent litigation was based. It opened the juridical gateway to all the Human Rights Act claims that followed, but also set the mood music for wider classes of claim. The principal issue considered whether the territorial scope of the European Convention was capable of extending to Iraq, and if so, whether the Human Rights Act went with it. And this was in the context of killing of civilians by UK troops, capable, if the Convention and Act did apply, of engaging Article 2, including the adjectival obligation to investigate deaths. And the domestic courts held, unsurprisingly perhaps in light of Strasbourg jurisprudence, that the Convention did extend at least to military bases, and with Lord Bingham dissenting, that it followed that the Human Rights Act also travelled to detention centres in Iraq. And I've often reflected on Lord Bingham's dissent. It's quite hard, I think, to understand it as on the level of legal principle. And I do wonder sometimes whether he, as he often did, looked kind of over the horizon as to what might follow, and thought that at least the politically more sensible route would be to leave this as a problem for Strasbourg, not for the English judiciary, but we don't know. There were 6 cases before the Lords in Skeini, only one of which concerned a death in military detention. The others concerned cases outside bases. And as I said, the domestic courts allowed the former to proceed, but not the latter. But the Grand Chamber of the ECHR identified a more expansive basis for jurisdiction under principles of effective control and state agent authority, the meaning and ambit of which we've all been seeking to identify in the years that have followed. And the conclusions, at least of the House of Lords, were sufficient for the Baha Musa inquiry to be ordered. And I'm going to turn to that a little later. Before leaving Skeini, I should note that if there were awards for legal chutzpah, then the UK would have won a gold medal for an aspect of their submissions to the Strasbourg court, which was that it would be wrong to recognize convention rights in Iraq because that would be a form of human rights imperialism. And this bold submission led Judge Bonello in a feisty concurring judgment, his last on the court, to record this. It ill behoves the state that imposed its military imperialism over another sovereign state without the frailest impetus from the international community to resent the charge of having exported human rights imperialism to the vanquished enemy. It's like wearing with conceit your badge of international law banditry, but then recoiling in shock as being suspected of human rights promotion. Don't make them like Judge Bonello. Next, certainly from my own perspective, was the case of Jedda, who was, at that time at least, a joint Iraqi and UK national held on a UK military base without charge or trial for 3 years, suspected of involvement in IAD attacks against troops. Again, I'm going to return to the context in this case while I address why I think courts have taken different approaches in different cases, but it's instructive to note that at the time of the hearing before the House of Lords, there were still thousands of British troops on the ground in southern Iraq, facing significant numbers of fatalities, not least from IEDs. Never an ideal point to litigate claims against armed forces. See, for your notes, Liversidge and Anderson and Korematsu and the United States. In light of Skeini, there was no issue in Jedda that the Human Rights Act applied to govern his detention by UK personnel, and there was no dispute that his internment was incompatible with Article 5. Obviously, it is. The crux point was whether or not those rights were trumped by the fact that a relevant United Nations Security Council resolution invoked under Chapter 7 of the Charter governing the presence of multilateral forces in Iraq, which had annexed to it a letter from Colin Powell, the US Secretary of State, which made a reference to internment if necessary, whether that, as a matter of international law, qualified or effectively displaced Article 5 of the European Convention. And the House of Lords held that by virtue of the primacy, which it said should be afforded to Article 103 of the UN Charter, this meant that Article 5 rights were indeed qualified, or in real terms, of no real effect, so Mr. Jedda could carry on being detained indefinitely, without charge or without trial. Strasbourg, again, took a more expansive view. They dodged the issue as to whether or not 103 was a matter of principle capable of displacing Article 5, but held that in any event, even if it could, in order to override fundamental human rights, the Security Council would have to do it in much more clear and explicit language than in those resolutions. And Jedda also was important because it marked the first time in litigation of this nature that private law had been utilised, as well as the Human Rights Act. It was argued that his detention was governed by English law and that internment without charge or trial amounted, again, uncontroversially as a matter of English law, to false imprisonment. That was rejected by both the Court of Appeal and the House of Lords, despite the fact it was a case concerning a British citizen detained by British troops on a British base to which the Human Rights Act applied, and which was immune, as were all the troops, from Iraqi law and Iraqi legal process. That was fatal to that element of the claim, but it didn't preclude private law claims per se. It just determined that they needed to be adjudged by the local laws in which a person claimed to have wrongly detained damage. Thereafter, a whole series of cases were brought by individuals for remedies, both under the Human Rights Act, for breaches of Articles 2, 3, and 5, and under private law, be it the law of Iraq or Afghanistan, for damages, variously for loss of life, personal injuries, and unlawful detention. Now, these claims threw up a host of fascinating issues, and many of them were considered on the two occasions that the Supreme Court considered a case from Afghanistan called Serdar Mohammed, together at the same time with some Iraqi claims. Let me just say a little about Serdar Mohammed's case. It was determined on assumed facts as a preliminary issue, and those facts were not attractive. For the purposes of the hearing, it was assumed that Serdar Mohammed was, as alleged by the United Kingdom, a senior Taliban commander in Helmand at a time in which the UK was incurring tragically very high numbers of casualties. His claim was for false imprisonment, both under the law of Afghanistan and a claim under the Human Rights Act. And he sought, amongst other things, an order that he be released. And his claim followed that of a successful claim in a case called Maya Evans, in which the English courts had precluded the transfer of prisoners back to the Afghan authorities because of the risk of torture. So the effect of Serdar Mohammed's claim, if liability was established, is that effectively, as the government put it, he would be released back onto the battlefield, so which led my opponent to term it a lethal catch-22. Now, the case raised a smorgasbord of fascinating legal issues, and I mean, one of the people on my team was Professor Andrew Clapham from the Geneva Institute, and as we were working it up, I remember Andrew sort of commenting that the claim was akin to about a dozen different PhD topics rolled into one. Let me just pick out some of the issues that the courts grappled with. Firstly, the interrelationship between the Human Rights Act and IHL. It was argued by the MOD that not only did IHL authorize internment in a non-international armed conflict, but as with Security Council resolutions in Jedda, it mandated detention when necessary, and that trumped any human rights protections, not least Article 5 ECHR. Now, the court essentially rejected those arguments, but in what I think is a profoundly interesting analysis, synthesized the relationship between IHL rights and enforceable rights under the Human Rights Act, permitting claims under the latter for breaches of the former. And I think that is a profoundly important development in law. Another topic considered by the Court of Appeal and the Supreme Court was a return to the debate about whether or not Security Council resolutions can trump convention rights, with the Supreme Court effectively ignoring not only Jedda in the Grand Chamber, but a whole series of cases that followed it, save for the notable and in today's terms interesting dissent from Lord Reed on that point. The court also considered the extent to which troops were operating under the auspices of ISAF or the United Nations, their argument being that they were, and therefore no liability could attach to the UK. And another issue was the extent to which a doctrine called the Crown Act of State could preclude the claim under Afghan law, the trial judge having found that the detention, having considered evidence from experts, that the detention was unlawful under Afghan law. And this caused to be dusted down and rolled out the doctrine of Crown Act of State, normally understood as applying to denied colonial claims 150 years ago. And in a judgment that is, with the greatest respect, extremely convoluted and hard to follow, the court held that the doctrine would preclude a private law claim, albeit it couldn't preclude claims under the Human Rights Act. Now, the primary judgment of the Supreme Court, handed down in the early January of 2017, and that of the Court of Appeal that preceded it, represent, in my view, almost the pinnacle of domestic courts' assessment of the interrelationship between domestic human rights and international law in the context of armed conflicts. But from my own perspective, the most impressive, indeed I consider it an extraordinary judgment of the whole period, is that of Mr. Justice Leggett, as he was, now Lord Leggett, in the case of Alseran, which is in fact a composite judgment of two first instance trials, both extending to about 6 weeks each, held before him covering allegations of mistreatments and unlawful detention, both during the IAC phase of Iraq and the NIAC phase in Iraq. And the judge had to consider not only the complex, I mean, really complex disputed facts in the cases before him, but the application of those facts to the full panoply of complex issues, only partly determined by the high courts. Now, it's a long judgment, but it's a tour de force. And I have yet to find any equivalent example in any comparative jurisprudence. It is a magisterial treatment of the interplay between public and private law, between domestic and international law in all its aspects. The determination of the issues in Al-Waheed and also in Alseran led to hundreds of claims emanating out of both the Iraq and Afghan complex to be settled. The only two outstanding cases, to my knowledge, certainly the ones I'm involved in, are judicial reviews that seek inquiries into allegations that UK special forces carried out a systemic shoot-to-kill policy in Afghanistan. And I'm somewhat restricted about what I can say about that case, except for watch this space. I'll turn quickly to complicity cases. In the context of armed conflict, Rahmatullah concerned the obligations both under IHL and under a multilateral agreement, an MOU, of the United Kingdom to secure the release of a man transferred from the US to the US in Iraq, who was then rendered by them to Bagram Air Base in Afghanistan, where he was held for many years and severely tortured. And the Supreme Court, our Supreme Court, held that the writ of habeas was capable of being issued, notwithstanding that he was in in the physical custody of the US. And the court had no qualms in explaining why his rendition to Afghanistan amounted to a grave breach of the Geneva Conventions. In the context of counterintelligence, the Supreme Court was asked to consider the case of Belhadj as to whether a claim requiring a court to assess the legality of foreign states' criminal acts was justiciable. Mr. Belhadj, as some of you may know, was a leading opponent of the Gaddafi regime, and his claim arose when he and his wife were unlawfully detained by the CIA at Bangkok Airport, held and tortured by them in a black site in Bangkok Airport, before being rendered on a CIA jet, one that was used to render many of the Guantanamo detainees, including Serdar Mohammed, the very same jet, rendered to Libya, where he was met on the tarmac by somebody called Musa Kusa, the head of the Libyan Foreign Intelligence Services. Mr. Belhadj was tortured, sentenced to death after the standard 15-minute Gaddafi-esque trial. But before he was due to be executed, the revolution came, and Mr. Belhadj found himself as governor of Tripoli, and was therefore in charge of the former base on which he was being held, and handed over a load of paperwork to Human Rights Watch in the New York office of Human Rights Watch. And one of the things that emerged was a fax from a gentleman called Sir Mark Allen, who was then head of counter-terrorism at our MI6, going along the lines of, it started, "My dearest Musa," and then talked about the transfer of Belhadj and claimed credit for the delivery of the cargo. So Mr. Belhadj then brought proceedings, and Ms. Boucher then brought proceedings here against the security services, against Sir Mark Allen personally. And when the Sunday Times led with a story, having been briefed by the spooks that this is all signed off by Jack Straw was brought in too. But the interesting legal issue in that case was the doctrine of foreign act of state, which the government said precluded the courts from dealing with matters that may require it to critically examine the actions of other states. The court was having none of it in the context of claims of this nature. The court would examine what it requires to examine in order to ensure a fair determination of the claims. There are still cases of that nature proceeding. This summer, the Supreme Court will hear a case called Abu Zubaydah, albeit not about the substance, about the question of applicable law and what law applies to govern his case. But that is, again, I'm afraid, what appears to be a sad tale of UK complicity. So look, this is only a very brief summary of a small number of cases. There were many more before the courts, many of them raising equally as profound and interesting issues. And I've been able to give you no more than a taster, but I do want to turn to the next part of my talk, which is why? Why did the courts adopt this approach? Why were there so many claims? What's led to this really generational shift? And of course, as with many complicated phenomena, the causes are multifactorial. And no doubt there are many reasons that we'll only be able to properly judge once more time yet has passed. I mean, as many of you will have heard the saying that we're only now starting to understand what caused the French Revolution. But I am going to suggest a few causes as what was going on. Firstly, we live in an age, and have done since the close of the Second World War, that has been fueled by the long shadow of the Holocaust and thereafter by the politics of the Cold War, in which human rights have had an unprecedented prominence in law as in society, including rights now deemed to be universal, enshrined in international documents that aren't simply gathering dust in chanceries, but are pasted on classroom walls across the world. And this has forced a change in perception of what international law is about, or what it should be about, from being a matter relevant only to interstate relations to one that guarantees universal rights to all individuals. And crucially in human rights law, in contrast, in fact, to much of IHL, it's been increasingly understood that it's not simply the contents of rights that matter, but the ability to enforce them. Most people correctly believe that rights that cannot be enforced are no rights at all. The second factor is we live in an age in which technology means that people can now see in their living rooms the realities of war, including on occasion reportage of atrocities that in an earlier age would have been hidden from public view. And therefore the public demand for accountability is heightened. Now, of course, that's been a factor since at least the Korean War and more significantly Vietnam. But the advent of phones on cameras and online blogs explain why cases such as mistreatment of detainees came into the public domain in the first place, and why the increasing worldwide access to the internet explains why it's now conceivable that citizens of remote foreign countries can publicize their plight to the international media and make contact with human rights lawyers in London. Thirdly, the cases were received by a judiciary with a very different skill and mindset than a few generations ago. Now, to be clear, I'm not suggesting today's judges are more consciously political than previous generations. I really don't think they are, nor that they are in any sense more inclined to look unfavorably on the military. I really don't think they do. In my view, the judiciary remains a small c conservative institution, both in composition and outlook. And in any event, English courts have for centuries been jealous and independent guardians of liberty and fundamental rights, not least protection from torture. But what has changed, in addition to the general prominence of human rights, are two significant factors. The first of those is that since the 1970s has been the re-emergence and development of judicial review, increasing the areas in which the courts have been permitted to intervene in government business, including into areas traditionally thought to be the exclusive remit of the royal prerogative. Judges have become increasingly comfortable in intervening into what has been considered previously constitutionally inappropriate areas. That has been coupled for the past 20 odd years by the Human Rights Act, which has been significant not just in itself, but because it's trained a generation of judges to be conversant in the language of human rights, and it's forced them to engage with international law in a whole range of cases. So thus they didn't encounter any of these military cases as neophytes. And fourthly, and my last point on this, is that the identification of the governing principles in a number of these leading cases has been heavily influenced by the particular facts of the cases that ended up before the courts. Lawyers and judges often like to pretend that all cases are decided purely on legal principle. But law is human-made and moulded by human experience, including prejudice, however much one might pretend otherwise. Now, I don't mean or need to be sycophantic to say truly in this country we are blessed with an independent judiciary which at its highest level is populated by truly great legal minds. But no judge, I think, or very, very few judges, are immune to facts, nor to the consequential outcomes of their decisions. Thus, although perhaps not determinative, I anticipate that the outcome of cases such as Skeini might have been very different if one of the 6 cases wasn't that of Baha Musa. Because most judges reading the facts of that case and viewing the photographs of his body would have felt repelled by the notion that law would deny a remedy to his family, not least the right to an investigation into his death. I equally suspect that the more expansive decisions of the Strasbourg court in that case in Jedda were driven by a sense of outrage at the lack of legal basis for the invasion of Iraq. But the other side of the coin is that I suspect that the principles identified in Jedda and again in Serdar Mohammed might have been different if British troops weren't being killed on the ground in Iraq and Afghanistan at the time. And also, if they were not brought on behalf of individuals suspected of serious acts of terrorism. But the outcome might have been different if by the time of the hearing they had been demonstrated to have been wholly innocent individuals wrongly deprived of their fundamental rights. It is a truism of all litigation that good facts make good law. So let me turn finally to the last part of my talk, which is just to address, have the courts got the balance right? Is it appropriate that foreigners who claim they've been poorly treated by our armed forces or by our security services abroad can come before our courts and seek remedies under the Human Rights Act and under private law? Is it right that we, in the domestic courts, have interpreted and indeed developed international law, including IHL, to give effect to those rights? Now, certainly not everyone thinks so. When the Supreme Court held in a case about complicity with the US in the mistreatment of detainees in Guantanamo, the Arawi litigation, that the common law wouldn't contemplate secret hearings, the coalition government introduced through primary statute closed material proceedings, allowing them to do exactly that. In response to many of the claims that I've been discussing, requiring the UK to pay millions of pounds in compensation to hundreds of claimants to the delight of the Daily Mail, the government introduced the Overseas Operations Act that sought to cut down the ability to bring in such claims, and we still have the British Bill of Rights hanging over our heads, which would have the same impact, if not worse. But I would argue that the balance that has been struck by the courts has not only been legally sound, but it's also an outcome that has served the public interest, not least by increasing respect for the rule of law, including the importance of compliance with international law. And I'm going to end by just making 5 short observations as to why I think that's the case. Firstly, in a country that, until recently at least, prided itself on upholding the rule of law, it is essential and was essential that no institution of the state is seen to be above it. Nothing is likely to do more damage to any emanation of the state if it is seen to be unaccountable, particularly so when the subject is human rights. When it comes to breaches of human rights, a distinction between what occurs within our territorial waters and what we do in foreign lands is not one, rightly in my view, that is legitimate. The public would have been right to be outraged if the answers to the claims brought, for example, by those alleging torture by UK troops were told that there could be no redress before our courts because it was all attributable to the United Nations, or that claims concerning complicity with third-party nations could only be dealt with on an interstate level, because to do otherwise would give offence to the torturing nation. So it's important to uphold international rule of law. Secondly, the practical application of international law by our courts, recognising how it can be utilised through the prism of both the Human Rights Act and private law, to provide meaningful remedies to victims, is a positive development in international law. it defeats the objection that international law is essentially a tool for diplomats and a subject for academics. It gives, no offense intended,
None taken.
it gives real meaning to the promises set out in human rights treaties, and it is not inappropriate for domestic courts to develop the ambit of international law if they are required to do so to give effect to the cases that are brought before them. And thirdly, flowing from this, the embracement of judicial accountability should enhance to serve the standing of the very institution against whom claims have been brought. Acceptance by the Ministry of Defence of review by an independent judiciary and the right of litigants to pursue claims against them should be seen as a very public manifestation of the commitment of the armed forces and security services to human rights and the rule of law. You can't effectively promote a message overseas as to the importance of rule of law while seeking yourself to deprecate attempts to hold you accountable for alleged human rights abuses before your own courts, a fortiori, all the more so when those complaints turn out to be well-founded. A public embrace by the military of the role of the courts in oversight is hardly a sign of weakness. The contrary, it should be a source of strength and confidence of purpose, that we combine modern military efficiency with the higher standards of accountability. It should help us immunize us against allegations of double standards. And accountability before the courts, I should say, as I have made this point to the MOD themselves, shouldn't not just be there to help victims when things go wrong, but is equally capable of providing protection to the armed forces when unfounded allegations are made against it, which is particularly damaging in this age of false news, Russian bots, and an internet buzzing with endless conspiracy theories. Courts, by contrast, thankfully deal with facts. They're capable of forensic analysis, absolute impartiality, and rightly maintain high levels of public trust. So judicial investigations provide a far more authoritative means of quashing suspicion of wrongdoing in the public's eye than any internal army investigation would ever do. The Al-Swady inquiry was ordered in response to allegations about unlawful killings in Iraq, and it was able to demonstrate that those allegations were without foundation. But assume for the sake of the argument that there had been no Article 2, or that you hadn't been able to enforce those rights before the courts, and that the allegations had simply been done by an internal military investigation from which the complainants were excluded or not represented to the same degree as they were in a public inquiry. Would the conclusions of an internal military investigation clearing itself have definitively set the record straight? Would it have put the issue beyond dispute? Would it have stopped the victims credibly continuing to advance their allegations? Would NGOs have been satisfied? And could the army and the soldiers accused of war crimes have walked away with a full sense of vindication? The answer's obvious. Fourthly, regulation by law, enforceable by victims before courts, raises standards. Nobody likes independent oversight, least of all great institutions of state that operated effectively without judicial challenge forever. Law, however, in many manifestations, plays a role, including through deterrence, in raising standards. And in much of the argument over the debate over the last few years about the role of courts in armed conflict, I've been reminded of debates in the 19th century when factory owners sought to resist the introduction of the Factories Act and the beginning of health and safety legislation in this country. They sought to argue that the legislation wasn't needed, or it should be left to industry to regulate because industry best understood, far better than courts would, the realities of industry, and that ultimately it would destroy their productivity and bring the country to ruin. In fact, the introduction of the Factories Act and subsequent legislation giving enforceable rights to remedies before courts has saved countless lives and limbs and has raised standards. And the Baha Musa inquiry, by way of example, reinforced the utility and importance of legal standard. It demonstrated in the most vivid way and tragic way imaginable what happens when those on the ground don't consider themselves bound by the rule of law. Now, fifthly and finally, I want to give you my personal perspective on a very human level about what redress under law can mean for human rights victims. The Alseran trial required a number of Iraqi claimants and their witnesses to travel from Iraq to the Royal Courts of Justice in London for trials that together lasted almost 3 months. They were given every opportunity to give their evidence about what had occurred to them before a patently independent tribunal. They were able to rely on lawyers who were willing to represent them. They were able to watch as very many military personnel, including generals and admirals, were called to give evidence and were cross-examined. And they received highly detailed reasons why the court found as it happened in their favor. To those men, it would have been unthinkable that they could have enjoyed similar rights under Saddam, and indeed probably the same today in Iraq. Those individuals had all been mistreated by UK personnel, or been treated cruelly, but it is hard to convey to you the level of respect that their experiences here engendered to this country from those individuals, and the sense of the role that the rule of law plays here. They left this country with their dignity restored by that process and through that process, and with respect for the institutions of this country. It was what human rights accountability is all about, capable of enforceable rights by the powerless against the most powerful. And that's a theme that I've seen not just in the courtroom. In 30 years of practice representing human rights victims from across the world, one of the most powerful moments that I've seen, and one of the greatest examples of restorative justice that I have witnessed, was the mediation of the civil claim of Baha Musa, in which the Adjutant General of the Army attended and personally apologized in sincere and sensitive terms to Baha Musa's father and to the other men who'd been tortured in the same room and the adjoining room to Baha Musa. Now, the impact on the family and to the other victims of that apology was transformative, both to them individually on a personal level and also to the litigation, which readily resolved. And I should say, by way of side comment, my experience of representing victims of all sorts of human rights abuses committed by a wide range of state and non-state actors is that the most valuable remedy is often an apology, not least because it provides affirmation that a wrong was committed, which appears in many cases to be of paramount importance to victims, particularly of violence. Another example is Belhadj, in which the litigation was resolved because of an unconditional apology by the Prime Minister and the Attorney General to Mr. Belhadj and his wife, repeated on the floor of the House of Commons. A similar direct and personal approach resolved Mr. Rahmatullah's case. The apology in the Mama litigation that you mentioned is still of extraordinary importance to the victims of colonial violence in Kenya. Now, these are all results that have only been possible because of the approach adopted by our domestic courts to the question of securing accountability for wrongs in international law. Of course, there are many voices on both sides of the debate that seek to unsettle that balance, including from those for whom the international legal order is simply a dispensable inconvenience. But for my own part, and not without qualification, I consider that the balance reached has been fair, true to the purpose of international law, and has advanced the interests of all of us. Thanks.
Thank you very much, Richard, for that powerful talk. I think we have around 10 minutes for questions. So we have some people online who may want to ask questions. I'll go and check whether they do have some questions. But if anyone in the room has any, Chaim is here with a microphone. We need it so that people online can hear what the question is.
So I'm going to use the fact that I'm holding the microphone to ask the first couple of questions. So first of all, thank you so much. That was so interesting. And I was wondering if you can say a bit more about two things that you brought up. The first thing is that the internet was a way to bridge between possible claimants that are abroad and would not have been able to bring their claims forward otherwise. I wonder if you can say a bit more about how you can bridge some other of the practical barriers that they might face, the monetary barriers, the language barriers, and so on, how they can bridge that and come over here to bring their claims. That's one question. And the other question is, how do you try and counter the effects that successful litigation can have political backlash and limit the ability to bring more claims, right? You mentioned that. That seems to be a very big problem, and that's something that appears to be happening in more and more jurisdictions. So I'm wondering if you have any kind of thoughts about that.
Yeah. Can I follow up? There's one question online, which I think is related. A colleague of ours, Ralph Wild, is playing the devil's advocate. It's a long question, but the gist of it is there not a danger that these cases have pushed things beyond what is politically acceptable and risks what we have seen already with Russia, which is that states will withdraw entirely from being bound by the enforcement of human rights law, both territorially and extraterritorially, in order to bring a halt to extraterritorial scrutiny?
Yeah. So Ralph's question and Heimer's your second question is kind of melded into one. So I'm going to answer those together, but let me just deal with the first one first. So there are great practical difficulties in bringing these cases, of which technology provides some answer. So you can communicate much more readily with people in Iraq or Afghanistan or Yemen or wherever cases might come from, and more to the point, they can find and they can make contact with the solicitors who bring those cases. But that's just kind of one aspect that makes it easy. Funding those cases is incredibly difficult, yeah? And you can't get legal aid, those cases. Right at the beginning, you could get legal aid, but then that was changed by regulation rather deliberately. You won't get city firms who could afford to run that litigation to want to take it on, because for obvious reasons, it's an unattractive proposition. And most human rights firms are not rolling in cash. Controversially, the public law cases, which can be run with public funding to some degree, are easier to run, but the private law cases are very difficult. And I actually don't think they would have run if Lee Day hadn't been committed to doing them. So, they would have put in, nobody started Iraq litigation thinking this is a surefire winner, right? And, but they were just incredibly committed to doing it, notwithstanding, huge risks to them, because it was done under a conditional fee agreement. So if we'd lost those cases, they would have got nothing, and millions of pounds would have been written off, but they were committed to it. So that's a very practical thing. I'd say generally technology, this is a slight drifting off your question, but generally technology is becoming an increasingly vital tool in human rights litigation. So even in the years since the Alseran trials, what you can do by way of reconstruction and using data to remodel what has gone on in a human rights event has changed beyond belief. So, we were kind of looking over maps to try and show which unit would have been in which given path near Basra at which given day, and then trying to get disclosure of diaries to try and prove it. And it was incredibly difficult to reconstruct a case which really turned on facts as to which unit was where on what day and where the Americans were. Now, nowadays, the kind of data that's available that you can reconstruct it and to which you have public access is being transformative in a whole range of human rights cases. So, I worked on a case to do with the shooting of Mark Duggan, in which Forensic Architecture, who this amazing human rights outfit at Goldsmiths, could reconstruct from using thousands of different data points what was going on the ground. It was an amazing tool. We're using that in a range of litigation now. So that's helped transform things. So then we come to the tricky question, right? Which is, what's the risk when you run these sorts of cases that actually your short-term victories might ultimately set things back? So a few things to say. One, in many areas of law, it's really important to have that at the forefront of your mind. And there are areas in law in which you have the luxury of being able to pick your cases. And, you know, going back to good law makes good cases, you pick the good facts, good facts make good law, you pick the cases. And, you know, lots of the development of private international law in terms of the human rights context has been very deliberate. It's not like that when you've got a client who's approached you, who's in detention and has got a good legal argument that they're being unlawfully detained. You don't, as a lawyer, really have the option of saying, yeah, you may be held unlawfully, but you know what, your facts of your case are pretty unattractive, so we're going to let you stay in the cell because it may be that someone else is going to come along with better facts. So that hasn't been, although there's been obviously quite a lot of strategic thought and definite concern about what would be the pushback from government, to some degree, as a lawyer in the human rights field, you don't always have that luxury. You just have to deal with the case and the client that you've got. Then there is the more general kind of dilemma that you face as lawyers, which is you think, what's going to be, you know, should we take this, you know, when you do have a choice, should you take this case, should you run it? You think it's a legally important principle, but you think, you know what, the government's going to hate it. They're going to legislate, they're going to push back, they're going to do X, Y, and Z. And that's a really interesting, it's a massively interesting point for lawyers. It's also a massively interesting point, I think, for judges. And, you know, there's a whole thing now, this is again slightly veering off topic, but there's a whole thing now as to, you know, there's been a lot of public concern about the way, for example, the current Supreme Court are looking at public law. And are they trying to effectively stave off the risk that government's going to abolish large sections of judicial review by steering this conservative line? And you know, even The Economist is talking about the Supreme Court in those terms. And I just think whether that's in the context of judges or it's in the context of people like me making strategic choices, ultimately, you've just got to run it if you think it's the right point and it's the right point of principle. Because the moment you start cowing, that's not to say you can't be clever and you can't be smart and strategic, but the moment you start running legally important and good legal points because the government might legislate, or you let that be the determinative factor, we're in trouble, right?
So we're a little bit short on time, so maybe we can have one question. We have no more questions from the online audience, but we have a reception outside waiting for us. So I'm sure Richard will be available to answer questions then. So maybe one question now, and then we'll, or maybe two questions, if you can. So maybe then keep it for the reception afterwards.
Thanks, Richard, for your tour de force. Just to welcome your thoughts on one other element of the British legal response broadly, especially on Iraq and Afghanistan, is why, despite all these civil claims you mentioned, which also ended up documenting, showing how many abuses took place, both the response on the criminal justice has been very limited, both domestically and internationally. This didn't result in prosecutions for the crimes. And is it true, as I work for Human Rights Watch, we seem to sense that there's a widespread belief, not just domestically and internationally, that whatever happened in Iraq, it was a very limited amount. So what's happened in these civil claims hasn't become more widely known about the extent of the abuse.
Yeah, I just don't think we as a nation are very good at reflecting on our own wrongs. And, you know, I say that having, you know, litigated colonial abuses as well, and sort of rather hope that the cases will be a kind of a turning point for a bit of reflection in this country. But that's not what we do. And, you know, most of the press coverage about the Iraq cases has been the negative stuff. It's been the attacks on lawyers. It's been Cameron at the dispatch box, you know, naming and trying to shame lawyers. And if I think of I mean, there were I just thought it was utterly frightening and outrageous in equal measure. The SRA, Solicitors Regulatory Authority proceedings against Lead A. It's another matter in respect to Phil Shiner and public lawyers, interest lawyers, but against Lead A, it was just had all the hallmarks of things that I've witnessed in other countries, in other fragile democracies or repressive regimes. And the newspaper coverage of the proceedings against, 3 brilliant committed lawyers, with whom I used to tear my hair out because they were so fastidious about everything. Newspaper headlines attacking them, which was, front page of the Mail, front page of the Express, front page of the Sun, editorials, David Cameron, compared to almost non-pickup of Alseran. All these litany of findings about what the British troops have done. I just thought was deeply, deeply depressing, and I do think there've been lessons learned from the MOD. I mean, I was invited in to do a talk to senior service personnel and civil servants in the middle of all of that. I do think some lessons have been learned. I think what may happen if a public inquiry is called into the allegations in Afghanistan, which are perhaps by a factor more serious on their face, the allegations, than anything else that's arisen, which is of repeated shooting of civilians by the SAS over a number of years, I think that might be a point at which it's just impossible to ignore. But I just think it's depressing, and I think, sometimes as lawyers we like to think we can change things on a meta level and not a micro level, but I'm not sure that's right, sadly. I sort of like to think it is.
Well, thank you very much. I think we're out of time.
Oh, you were just taking one more. Sorry, I'm not. Okay. You're running the show, not me.
Well, maybe just a quick one, because we can continue after.
I'll give a quick
outside.
I was just interested, therefore, following on from the last bit of your speech, which was, what do you think is the most effective forum for dealing with these issues? Is it domestic courts? Is it international courts? Is it public inquiries, as you were just talking about? Is it the UN, parliamentary committees, and so forth? Where do you think is the most effective of all of those? And
so I think the question, to me, it's effective for whom? So undoubtedly for me, effective for a victim's perspective, is getting something before a court that has powers to determine what happened and to provide remedies if appropriate. So, I'm unsurprisingly a great believer in court cases because of what it can do for the individual victim. In terms of affecting more long-term and profound change, then I'm not sure, just as I was answering to Clive's question, I'm not sure that's necessarily the most effective route. Public inquiries may be, parliamentary pressure. Sometimes it's outside law, right? Sometimes it's politics. At the moment, all political parties are frightened of saying anything to do with the armed forces. It took, in terms of the Overseas Operations Bill, as it then was, it only really got amended significantly because the generals intervened to say, you can't go this far because it's going to end up without, this is so hopeless, it's going to be more soldiers going to The Hague. It was the generals that changed it, not any of the opposition parties, really. So, although, Labour did oppose it, I should say, but I think it was the intervention of the generals that made a difference. So I don't think there's a single answer to that question. I think the answer is probably depends.
Well, thank you very much for this really powerful talk. So if you can join me to thank Richard one more time with a big round of applause.